Welcome to this lecture on cybercrime and digital evidence. The session is divided up into 4 sections. The first 3 consider the core concepts, processes, relevant cases and law for cybercrime, digital evidence and digital forensics. The remaining section provides a number of case studies which will be discussed in small groups during the tutorial sessions. This is lecture 2 in our cybercrime and digital evidence series. This lecture is digital evidence. One of the more accepted definitions for digital evidence is that of Johan Casey in Digital Evidence and Computer Crime, where he describes digital evidence as any data stored or transmitted using a computer that support or refute a theory of how an offence occurred, or that address critical elements of the offence, such as intent or alibi. The bottom half of this slide provides a range of common digital artefacts that may be presented as digital evidence. These are arranged from left to right, from those that are easier to identify and analyse through to those that can be quite a bit more difficult. While files such as those created by a word processing application, or plain text messages like email and SMS, and log files are generally found in plain text and are easy to analyse, when we start to review temporary and cache files, issues can arise either due to the way in which those files were recorded, or the sheer volume of individual small files that may result from even one brief internet browsing session. In cases like the Casey Anthony infanticide trial in America, problems with analysing cache files were central to the failings of at least 2 digital forensics experts, as seen in their expert witness testimony. The volume of data is also a key issue when seeking to analyse simulation or virtualization data, such as we might see used to develop and train artificial intelligence systems. And the difficulties of analysing some forms of encrypted data, such as the stored data on iPhones, has previously been headline news. Prior to existence of digital data storage devices, the best evidence rule, which has been in use in the United Kingdom since at least the 18th century, meant that the original writing or recording or picture needed to be produced in court, unless these had been destroyed or were unavailable, in which case a certified copy or duplicate may have been admissible. The best evidence rule is best summed up in the current version of the Manual of Service Law for Military Police, shown here. This common law rule of best evidence had been applied in many jurisdictions, including Australia, but over the years there have been many challenges, particularly with respect to the difference between a hard copy document, i.e. something on paper, and a soft copy document, a digital file. Some examples of these differences included that there could be differences between the hard and soft copy versions of a document, such that some information associated with the creation of that document might only be visible during examination of the digital version. So if you think about a Word document, that might be the comments and alterations. Hard copy documents need no special tools and can be viewed and read by the naked eye. However, soft copy documents require the appropriate computer hardware and software in order to be viewed. Soft copy documents can easily be altered. Soft copy documents can easily be copied and disseminated. Now, the rules of evidence developed over many years at common law and were finally encapsulated into the Civil Evidence Act of 1995. And cases like Masquerade Music Limited versus Springsteen in 2001 in the Court of Appeal have confirmed that the best evidence rule no longer exists. In providing his title to certain music recordings that were being manufactured, imported and sold by Masquerade Music, Bruce Springsteen relied on secondary evidence from his previous solicitors of copyright assignments that they recalled making on his behalf in musical works that were recorded in 1972. And even though these were clearly not the best evidence, certainly not as good as having the original contracts, the solicitor's statements were accepted by the court on the basis that a reasonably thorough search had been conducted and that Mr. Springsteen could not produce the originals without some difficulty. Masquerade Music appealed on the basis of the best evidence rule, And in delivering his judgment in favour of Bruce Springsteen, Lord Justice Parker said, "In my judgment, the time has come now where it can be said with confidence that the best evidence rule, long on its deathbed, has fully expired. In every case where a party seeks to adduce secondary evidence of the contents of a document, it is a matter of the court to decide, in the light of all circumstances of the case, what, if any weight, should be attached to that evidence." Under Section 18, Part 1 of the Police and Criminal Evidence or PACE Act, a constable has the right to enter and search any premises occupied and controlled by a suspect who has been arrested on suspicion of an indictable offence, where that constable has reasonable grounds for suspecting that there is evidence on the premises relating to that offence or some other indictable offence which is connected with or similar to that offence. If an officer is acting under power of Section 18.1, then he or she would be lawfully on the premises for the purposes of Section 19. Now, Section 19 specifically deals with digital evidence that might be seized from computers or other electronic devices found within a premises. The power of Section 19, Paragraph 4 includes the power to download electronic information to a disk or to print copies of computer files that can be taken away from the premises. The phrase accessible from the premises may also mean any data that is remote but accessible from the computers within the premises, such as data stored in cloud storage accounts or other online services. These may also be subject to the power of seizure. Section 19.4 is extended beyond the general seizure powers by virtue of Section 20. Even where digital evidence is being searched under a civil seizure order, where evidence is found of a criminal offence, this evidence may be passed on to criminal law enforcement. In CPLC and W&P, the applicant, W, an independent computer expert, applied to the Chancery Division of the High Court for direction regarding highly objectionable images of children he found in the course of executing a civil search order. Even though P, the plaintiff, had invoked his right against self-incrimination and an independent lawyer was overseeing the process of identifying material in the computers belonging to CPLC, the court found that the domestic right to privilege had to be weighed against the right of the public under Articles 3 and 8 of the European Convention on Human Rights, which is to be protected from criminal activity. W in this case was directed to pass on the objectionable material to police. So what this is telling us is that even where the search that's being conducted has no relationship to a criminal investigation, if in the course of that search you find something that is criminal, you may be directed to pass that on to, and it may be well within your right to pass that on to law enforcement. An example of this happened to me about 10 years ago, where I was asked to install software on a computer network of a multinational company. And that software would go out and would search all of the computers that belonged to the company that were used by the staff to perform their work tasks. One of the computers belonged to a chap who had been overseas for a little while on behalf of the company and had come back with his laptop. On his laptop, he had about 42 gigabytes of some fairly extreme pornography. And whilst he had the employment agreement that he had with the organisation said that his computer was not to be used for personal or private or non-work related tasks, it was deemed that this pornography, not only was it not a work related task and so therefore it was a possible sacking offence, but it was also that some of the pornography that he had there was illegal, or at least was on the borders of being illegal. But that wasn't a judgment for me to make, and it wasn't a judgment for the employer to make. The best that we could do was that we follow this particular judgment, and it was handed over to the police for the police to look at and decide whether or not an offence had been caused. In that particular instance, he was prosecuted, and he was given a home detention sentence for some of the material that was on the machine. Modern technology has also given rise to a new form of information about digital information. This is known as metadata. Metadata is information that describes the digital record, be it an email or a text message or a word processor document or a photograph. Every time we use any digital service from our devices, or even simply as we walk around town carrying smartphones, we actively and passively leave digital traces. Traces of where we've been, what we were doing, the apps we accessed, the services we used, how long we paused somewhere. And with the advent of what proved to be patently useless track and trace apps, the details of other people we were close to at any given time, whether close to meant standing beside them, or as it did for many thousands of so-called contact tracers, on the opposite side of a wall, and therefore not remotely in direct contact. Descriptive metadata is used for finding or understanding the digital resource. Administrative metadata is an umbrella term referring to the information needed to manage a resource or that relates to its creation. Within the administrative metadata sphere are three types. Technical metadata, which is information about the digital files that's necessary to decode and render them, such as file type. We've got preservation metadata, which supports the long-term management and future migration or emulation of digital files. For example, it might include the checksum or the hash to ensure that the file is verified. And then we've got rights metadata, such as a link to Creative Commons license, which details the intellectual property rights that are attached to this particular piece of content. Then we have structural metadata. Now, structural metadata describes the relationships of parts of resources to one another. Examples might include pages in a sequence or a table of contents with pointers to the beginnings of milestone sections. And structural metadata connects different resolutions or bit depth representations of identical content. Markup languages mix metadata and content together, a practice only sometimes used with other forms of metadata. Flags inserted in the content denote notable features. For a text resource, this might mean marking structural elements such as paragraphs or flagging words with semantic information, that the word is a place name or a certain part of speech. Or it might mean providing formatting information such as an instruction to put the word in italics. Now, different categories of metadata support different use cases in information systems. Discovery is perhaps the most common, with structured metadata allowing users to search for or browse to find resources or information of interest. Many metadata properties are useful to display to users to aid in identification or understanding the resource that they're looking at. Interoperability, the effective exchange of content between computer systems, relies on metadata describing that content so that the systems involved can effectively profile incoming material and match it to their own internal structures. Metadata supports digital object management by providing information needed to render digital content appropriately or deliver the appropriate version to match a user's need. Preservation is achieved through creating metadata that allows verification of the integrity of content after it's been transferred and at other notable points in its life, and signalling when preservation activities such as a format migration or an integrity check have occurred or need to be undertaken. Finally, metadata supports navigation within parts of items. For example, from one page or section to the next, and among different versions of objects, such as varying resolutions of a photographic image. Let's consider a few examples. Take that email you sent this morning. What types of information do you think that email contained, or created as it was sent through the internet? Now, most people will get the obvious ones. Recipient and sender email address, the time and date that the email was sent and received, the subject line, and of course the actual email content. But what most people do not realise is that additional information is created, as the email passes through their router, their internet service provider's systems, the mail servers of the email provider, and even when it's downloaded to the email client software of their recipient. Which of the elements shown on screen do you think are the principal fields that are protected and thus require a warrant to access, and which are the metadata? You might be surprised to know that the laws of most Western countries protect only the content of the email. Every other data field related to that email is considered to be metadata, which, in most jurisdictions, does not require recourse to a full bench warrant. And in some countries like Australia, it's data that's available simply on formal request to your ISP by organisations such as the RSPCA, local councils, greyhound racing clubs, and even private investigators. Now, let's consider accessing a web page. When we open our browser and we type in the web address of somewhere we want to go, a number of things happen. First, our computer makes a DNS request to translate the web address that we typed in, say www.sra.org.uk, into the IP address of the server that hosts that web page. Then, the browser requests the web page from that server, receiving the HTML markup and the other assets like images and scripts that will render the page in our browser on our computer. At every page of this process, metadata is being created that ISPs in many countries retain for extended periods of time. In fact, in many countries they are required to retain this metadata by force of legislation. In the UK, this data is known as Internet Connection Records, or ICRs. An ICR shows which web pages you visited, the relevant IP addresses and computer details, and how much you downloaded. While ICRs are not supposed to show which specific pages within the website you visited, the Investigatory Powers Act has now allowed retention of these records as well, with Section 16 recasting metadata as secondary data, in a typical government mealy-mouthed attempt to make it seem like secondary data is something entirely different to the metadata that many security consultants tell us is being collected and used against us every day. While the Investigatory Powers Act speaks of obtaining a warrant for access to this data, such warrants may not necessarily need to be received from a judge or a court. They can be issued secretly, if considered urgent, on request to the Secretary of State of England or to any of the Scottish ministers. Effectively, these so-called urgent warrants are a political tool, not a judicial one. In countries like Australia, under very similar legislation, a police officer, RSPCA officer, someone from the local greyhound authority, someone from a local council need only make this request to their manager or the senior officer on staff on a pro forma letterhead document, and once signed by that person, that document carries the same weight as an urgent warrant issued here in the UK. Metadata can also be intercepted and potentially delivered to police without a warrant at all here in the UK if one party, sender or receiver, consents. If the postal, internet or wireless telephony service provider collects it as part of administering or maintaining their services, or where one party is an inmate in a prison, mental health or immigration facility. Whenever we make a mobile phone call, the number we dial, the time and date, the duration of the call, and even our location, triangulated by the network provider, are all metadata that is available. As is seen in similar legislation in Australia, New Zealand and America, our Section 57 makes disclosure of the existence of a warrant or the details of the target person or the data that was collected or even the process that was involved in collection unlawful. So your ISP or telephony provider are restrained from even telling you that they have received or responded to a request for your information. Further, there are provisions within the Act that mean the police or intelligence services don't even have to disclose to the prosecutor or the court that they used your communications data as a shortcut to catching you in commission of some other more tangible crime. The metadata we have seen now, that is created when we email our friends or make a phone call or even listen to music on Spotify, is described as actively created metadata or active metadata. Its creation results from some dispositive act on our part, a choice. We posted something online, we emailed our friends, and we chose to listen to that song. Passively created metadata, or passive metadata, arises involuntarily. When a website or app polls the geolocation data of our laptop or smartphone, and that information is, well, at least at the time, unnecessary to serving up the website or app. When websites download cookies into our browser cache that they can later upload when we access the same site from a different location, and thereby enable tracking us. And nowadays, your passive metadata cloud, or what we know as digital shadow, is being collected even as you walk down the street, as you drive along the highway in your car, and as you enter or leave public buildings like airports and shopping malls. Almost every motorway and many A roads in the UK have some form of blip track solution installed along them. Some look like the white boxes shown here, while others look like a little rectangular paddle about the size of a large iPhone attached to a light pole. Blip track captures the hardware MAC address and any user-defined friendly names for any Bluetooth or Wi-Fi enabled devices as they pass by these collector boxes on the highway. This includes not only the smartphones, tablets, and laptops and wireless headphones that may be in your car, but also the car's stereo infotainment head unit and, where fitted, the tyre pressure monitoring system devices or TPMS that are installed in each of your wheels. They were also introduced on the feeder roads to UK ports in 2015, such as in Dover, shown here. It is even used in UK airports to collect details as passengers move around in the terminal facility. While the details collected by BlipTrack identify individual devices, and potentially the owner of the device, given that many people name their device as something truly original, like Danika's iPhone or Thomas's laptop, these details are all considered metadata. Collection of this data on its own has been identified as a privacy issue, with police using BlipTrack datasets around the world while maintaining that they are not. But where an even bigger privacy issue comes into play is when the full BlipTrack dataset is merged with other data sources, such as the ANPR data and traffic camera feeds, and thus the police are able to link the Bluetooth and Wi-Fi metadata from your vehicle and its occupants to images of their face, the number plate and images of your vehicle, and build up a complete picture of where you've come from, where you're going, who you're travelling with, and when and how fast you got there. Leaving aside the extensive amount of metadata collected about us every day, in general, all evidence, including digital evidence, starts from the default position of being admissible unless it falls within a category of evidence which either must or may be excluded. You may recall from your evidence lectures that the categories that must be excluded can include evidence that was obtained in breach of a procedure that's described by statute, confession evidence that was obtained by oppression or in consequence of something that was said or done like a promise that would render it unreliable, evidence that was subject to protection by legal privilege, such as correspondence between you and your solicitor, evidence obtained through torture or inhumane or degrading treatment, and evidence excluded at the court's discretion, either at common law or under Section 78 of the PACE Act. Just as with any other evidence, digital evidence starts from the same fundamental test for admissibility, whether or not it is relevant to a matter in issue in the case. You should already have seen that the Criminal Justice Act 2003 provides that certain types of hearsay evidence are admissible, including cases where the statement of a witness may be adduced despite the witness not being available to give evidence at trial, statements contained in documents made in the course of a business, profession or occupation, previous inconsistent statements, and other previous statements of the witness, such as where it's being used as a memory refresher or to rebut suggestions of fabrication of oral evidence. Given the ubiquity of computer systems and electronic devices in almost every facet of our lives, it is inevitable that digital evidence will be used to prove material facts in criminal and civil trials. The difficulty, as some learned authors have noted, is that digital evidence, more than any other type, crosses the prohibition against hearsay. Where issues have usually arisen is where the computer evidence is being adduced as proof of the information or statement entered by a human operator. Courts have traditionally ruled computer evidence adduced as proof of information entered by a human as inadmissible hearsay. For example, in Ex parte 11, where records from a computer were used simply to demonstrate that the computer automatically recorded that transfer requests had been made, and they were not used as evidence that the transfers had actually been made. If they were being tendered to demonstrate that the transfer requests had been carried out and completed, which in this case required human intervention, they would be input statements by a human being, and thus would have been inadmissible as hearsay. The last case on this list, Ex parte Bullard, makes more clearly the distinction wherein the court stated in its judgment, when considering the application of the hearsay rule to a printout from a computer, it is necessary to distinguish between computer printouts containing information implanted by a human and printouts containing records produced without human intervention. To rely on the contents of the former is to rely on inadmissible hearsay, whilst to rely on the content of the latter is to rely on real evidence. I agree that this distinction is now established. In many cases, computer evidence will usually be found admissible by virtue of Section 117 of the Criminal Justice Act 2003, in which the Act contemplates business, profession or trade documents, where a fact in a statement will work its way through a number of people, but are all giving or receiving the statement in the course of business, whether paid or unpaid. A statement contained in such a document is admissible as evidence of any matter stated, provided that such oral evidence would have been admissible and that the requirement of Section 117(2) is satisfied. The Association for Chief Police Officers have published a good practice guide for the collection of digital evidence, which is widely accepted in courts of England and Scotland. And while they do not constitute a legal requirement and their use is voluntary, it could be argued that non-adherence can lead to exclusion of evidence that does not comply, subject to provisions of Section 78 of the PACE Act. An even more significant issue with digital evidence is the common law presumption that computers are reliable. This presumption has arisen from judicial use of terms like reliable and lawyerly use in court of terms like robust to describe the work of computers. But this presumption and the use of terms like reliable and robust are legal and technological fictions, and a fallacy that many cases have come to demonstrate. Cases that have demonstrated software accuracy issues with how police officers calibrate radar-based mobile speed detectors, for example. In the case of Police and Butcher from the Supreme Court of South Australia, the prosecutor unsuccessfully appealed a magistrate's decision to disallow computer printouts from a speed detection device used by police because that device had been demonstrably improperly calibrated by the officer. In Australia alone, prosecutions lost on the same grounds go as far back as 2005 and have continued to the present day, such that as a result of recent decisions of the courts in both South Australia and New South Wales, it is proposed that use of these handheld officer-calibrated speed detection guns, in Australia at least, may soon be relegated to the history books. In another series of cases that includes Tuart and the Queen, 2015, shown here, appellate courts upheld lower court decisions to disallow evidence involving likelihood ratios computed by forensic DNA analysis software called STRMix. These values were used to represent how likely it was that the defendant's DNA was found as part of mixed DNA samples collected at crime scenes. While the Australian Department of Health downplayed the issue several times as minor miscodes, between 23 and 60 capital cases across Australia, New Zealand and the United Kingdom have had to be revisited as a result of not less than 7 coding issues identified in the STRMix software. These errors relate to everything from how the software identifies DNA alleles through to how, in one case, it drastically overestimates the likelihood that a defendant's DNA is even present. This then brings us to one of the largest examples of when computer evidence was presumed accurate even in the face of overwhelming evidence that it was not, and one where the presumption would reverse the burden of proof, from the prosecution and Royal Mail trying to prove that theft had occurred, to the defendants in each case being forced to try and prove that theft had not occurred. The Royal Mail Horizon software scandal saw over 700 sub-postmasters prosecuted between 2000 and 2014 for false accounting and alleged theft of funds when Fujitsu's Horizon accounting software declared their till and branch account balances out, in some cases by tens of thousands of pounds. The system not only had what was described in court as bugs and defects, but these issues, coupled with absent and misleading evidence, allowed both the software itself and the Fujitsu technicians working on behalf of the Post Office to categorise software accounting errors as human errors that were blamed on the improperly convicted postmasters. The prosecutions were run on the basis that because Horizon's computer system claimed a shortfall existed, and the computer was in all cases presumed to be correct, the shortfall must have existed, and the postmaster must have caused that shortfall through theft or mismanagement. Cases brought by criminalised postmasters against the Post Office for compensation are still ongoing. When the dust settles, finally, potentially hundreds of millions of pounds will have been paid out to compensate those who were wrongly accused on the basis of this false presumption that a computer's evidence is robust and reliable. Consider the last quote from Lord Justice Holroyd, when he declared the Post Office's prosecutions of the sub-postmasters an affront to the good conscience of the court. By representing Horizon as reliable and refusing to countenance any suggestion to the contrary, Post Office Limited effectively sought to reverse the burden of proof. It treated what was no more than a shortfall shown by an unreliable accounting system as incontrovertible loss, and proceeded as if it were for the accused to prove that no such loss had occurred. Denied any disclosure of material capable of undermining the prosecution case, defendants were inevitably unable to discharge that improper burden. In your own time, I suggest you have a look at the digital evidence issues of the Casey Anthony trial that was conducted in 2011 in America. In this case, there were several computer experts, several digital forensics experts who were put on the stand by the prosecution who had analysed data that was taken from the computer of Casey Anthony's parents, which is the computer that she used within their house. Casey stood trial for the alleged infanticide of her young baby, and the prosecution's contention was that she had used the computer to look up evidence for how to kill the baby or how to get away with murder. However, one digital expert that was put on the stand incorrectly reconstructed and misread digital evidence from the browser logs and suggested that Casey had searched 82 times for how to make chloroform. It turned out she'd only actually searched for that once, and it was quite a while before the events that transpired with her child. However, another digital forensics expert who was brought in this retrial completely missed the fact that she'd actually searched for foolproof suffocation, and suffocation was the way the baby had died.